Thank you, Dr. Gosar. Director Comey, I want to go back to the issue of intent for just a second. We can disagree on whether or not it's an element of the offense. Let's assume for the sake of argument that you're right and I'm wrong and that it is an element of the offense. Secretary Clinton said that she was, quote, well aware of classification requirements. Those are her words, not mine and not yours. So if she were, quote, well aware of classification requirements, how did that impact your analysis of her intent? Because I've heard you this morning describe her as being less than sophisticated. She disagrees with that.
Well, I was talking about technical sophistication. The question is, I would hope everybody who works in the government is aware of classification requirements. The question then is, if you mishandled classified information, when you did that thing, did you know you were doing something that was unlawful? That's the intent question.
All right. Well, you and I are going to have to get together some other time and discuss all the people we prosecuted who were unaware that they were breaking the law. There are lots of really dumb defendants out there who don't know that what they're doing is against the law. But let's go with what you say.
I disagree. You may have prosecuted a lot of those folks. I did not prosecute a lot of those folks.
I was a gutter prosecutor and you were a white-collar prosecutor. Trust me, there are lots of people who don't know you can't kill other people. Let me ask you this. On the issue of intent, you say it was convenience, okay? You're a really smart lawyer. If it were convenience, Director, she wouldn't have waited 2 years to return the documents and she wouldn't have deleted them 4 years after they were created. So you can't really believe that her intent was convenience when she never turned them over until Congress started asking for them, could you?
Yeah, my focus, and I hope I made this clear, my focus is on what was the thinking around the classified information. I mean, it's relevant why the system was set up and the thinking there, but she didn't, I don't understand her to be saying, well, I think I've said it already, but that's my focus.
So I know I'm out of time, but it just strikes me you are reading a specific intent element into a gross negligence statute, not even general intent.
Gentleman's
a
time.
Specific intent
Gentleman's time has expired.
Yeah, I'm sorry.
Go. The director can answer.
I enjoy talking with him. The question you got to ask is, so why is it that the Department of Justice since 1917 has not used that gross negligence statute, but charging it once in an espionage case? And whether their decision was smart or not, that is the record of fairness. And so you have to decide, do I treat this person against that record? And if I do, is that a fair thing to do? Even if you're not worried about the constitutionality of it. And my judgment is no reasonable prosecutor would do that. That would be celebrity hunting. That would be treating this person differently than John Doe.